Welcome to Inside Business. Today we're going to go into chapter 2, resolving conflict in the marketplace. The part 1, law of contracts. Many deals agreed between the different stakeholders in the business involve contracts. Example given, the contract between an employer and employee. The Irish legal system uses the law of contracts to establish when the contract exists and when it ends. So for every organization, for every establishment, especially when it comes to employers and employees, there's always going to be a form of agreement between both parties that would ensure their togetherness. And that is what a contract is. So for the Irish legal system, it is based on the law of contract that stipulated that there is an existence of agreement between two parties and when it starts to end. So the definition of a contract is a legally binding agreement between two or more parties, which is enforceable by law. So an agreement that is enforceable by law, that means there's an offer and acceptance between two or more parties, which the law accepts, then that brings up a contract. So what are the elements of a contract? So the following elements must be present for a contract to be valid. So a valid contract must have the following elements: agreement, intention to contract, capacity to contract. Agreement, let's start with agreement, which is offer and acceptance. Intention to contract, which talk about the willingness of individuals, of the parties. Capacity to contract. Does the person have the person's ability, to enter into a contract? Consent to contract, which is the understanding from each partners, each parties. Consideration, which simply talks about what do we call it? The bargain for exchange, which means whatever happens in the contract, we must always have something that each party must have something that it gives to each other in return. The legality of purpose, whatever our objectives are, it has to be legal. It has to be legal. And legality of form, it simply talks about the document. The document must comply with the legal requirements. So let's start with agreement first. Agreement. For agreement to exist, there must be a clear, unconditional, and complete offer made by one party and accepted by the other party of the contract to a contract. So there is agreement because there's an offer and acceptance. So an agreement consists of two parts: offer and acceptance. So we start with offer. An offer is made when one party asks another to enter into a contract. The party making the offer must include all details and communicate the offer clearly. The offer must also be unconditional. In essence, there should be no strings attached to the offer. An offer can be made in a number of ways. So, agreement will come into place because certain party has, asked another party to enter into a contract. And whatever the party, whatever that individual or organization or institution has asked for, it can be either orally, writing, or by conduct. I want to talk about orally. It might be said with word of mouth, a written contract, or by conduct. Maybe a consumer handing a newspaper and money to the sales assistant at the checkout in the shop. So that means there's an action that brings about it. Then the second party must accept. So an offer can be terminated in a number, but before going to acceptance here, there are different ways in which an offer can be terminated. It can be terminated by revoking it, which means a withdrawal before there's withdrawal before acceptance. That is revoking. Rejection, that means the offer is rejected by the other party. Lapse of time. The party making the offer may impose a time limit on accepting the offer, which means there's a limited time that the acceptance has to be lapsed. So if the second party does not accept the contract within the period stipulated in the agreement, then the contract might be terminated. And the last one, death. If the party making or receiving the offer dies, then that's the end of the contract. Now, what is acceptance? Acceptance simply means you give your consent you agreed on the situation. So the person receiving the offer accepts all terms and offer. An offer can be accepted orally, in writing, or by conduct. Example given, a retailer now takes the customer's money in exchange for a newspaper. So it is an acceptance when you agree on what has been offered to you. So the agreement could be verbally, oral, that is orally, or by writing, or by conduct, by an action. The next element of a contract is intention to contract. Both parties intend to create a legally binding contract. Irish contract law assumes that all business agreements, either oral or physical, oral and written, are intended to be legally binding. So the intention to contract simply talks about the intention. That means whatever we discuss, whatever we need to talk about, must be legally binding. All social and private agreements are not intended to be legally binding. Example, if Kevin promised to tidy his bedroom and then doesn't tidy it, his parents cannot sue him for failing to complete the task. We only talk about both oral and written, which are legally binding on business. But when it comes to social or private agreements, it is not legally binding. As a result of that, no one can there's no litigation onto that. Then the third one, capacity to a contract. We're talking about capacity to contract. We're talking about the legal ability to enter into a contract. So I'm going to read. All people and businesses have the legal ability to enter into a contract, except for the following: any person under the age of 18, except for necessities, people who are mentally incapacitated, under the influence of alcohol, drugs, or of unsound mind. So capacity to contract is simply talking about the ability to enter into a contract. So those that can be exempted from entering into contract are those below 18, except for necessities, or people who are mentally incapacitated, probably because they are under the influence of alcohol or drug, or they are mentally unsound. The next one is consent to contract. The parties entering into a contract must do so voluntarily. A contract is invalid if a party is put under physical pressure, that is being pressurized, under duress, or threatened to enter into a contract. That means the person is put under duress to enter into a contract, or a genuine mistake is made by either party to the contract. Like a glaring mistake is made, then that means the contract becomes invalid. Either party is dishonest or gives false information that may encourage the other party to enter into the contract. So a contract might become invalid if one party has put up certain misinformation to influence the decision of the next party to go into that agreement. That is also an invalid contract. Then consideration. Consideration means that each party in the contract must give something of value to the other party. We call it bargain for exchange. So it means money or goods exchange between the parties. That means each individual in that party, in that contract, would have to give something in return for another. Employee would give its service or her service in return for wages paid by the employer. Legality of purpose. A legally binding contract must be created for a legal purpose. For example, a valid contract cannot exist to buy illegal firearms. So whatever form of contract we sign, it has to be legally, accepted. It has to go with the legal framework of the country. Legality of form. Contracts must be drawn up in the correct legal format. This can be done orally, in writing, or by conduct. Example given: a contract to purchase property or insurance policy must be in writing. So a contract, any document that has to be used for a contract must be on a legal format. Then we go to termination of contract. I'll be right back. So we continue with contracts. Now we're going to termination of the contract. A contract can be terminated through performance. That means I've completed my tax, I'm being paid for the tax, and the contract is done. Through frustration, maybe unforeseen circumstances that are beyond our control. Agreement, we both, despite the fact that we did not finish our contract, I propose that we end the contract and the second party accepted. Breach of contract, which can either be non-essential and essential. There's a breach of contract, and for every breach of contract, it means one party did not fulfill his or her own side of the agreement, and that might bring about an immediate termination. So let's go into it one at a time. So a contract can end through termination. Performance. One way to end the contract is through performance. So a contract ends by performance when both parties complete their side of the contract exactly as set out in the contract. So that means each party has done what he or she is supposed to do, and the contract ends. The contract between Jill and McHugh Motors ends when Jill receives the blue Hyundai i10 car and McHugh Motors receives the payment of 26,000 euros. The contract ends based on performance. Agreement. The contract ends by agreement when both parties mutually agree to end the contract, even if the purpose of the contract has not been completed. So we might not have completed our purpose, but we find out that we can no longer continue the contract. So we might come together on a mutual agreement to end the contract. After signing the contract to purchase a blue car, McHugh Motor informs Jill that the car can only be delivered in the color red. Jill is unhappy about this, and both parties decide to end the contract by mutual agreement. That is agreement. The third one, frustration. I'm going to talk about frustration. A contract ends when an unforeseen event arises that prevents the contract from being completed. Examples include extreme weather conditions, bankruptcy, or death of one party of the parties. These are external factors that might be beyond the control of either parties, and as a result of that, they might have to end the contract. For example, storms damage the Hyundai factory, and vehicles can no longer be manufactured. This ends the contract as the car cannot be delivered to Jill. And the last one is breach of contract. A contract ends when one party breaks their side of the contract. When there's a breach, it means one party has broken the side of its own agreement. And if this happens, if it is an essential element of the contract, then there might be an immediate end to that contract. But if it's just a non-essential, that's a warranty, then of the contract is breached, then the contract does not end. The party that broke the warranty may have to pay compensation on the innocent party. So if it's just about a warranty, then it is non-essential element, but it only needs compensation. So these are the ways in which a contract can. These are ways in which a contract can be terminated. So we'll go to how termination can bring about compensation. So what are the remedies for breach of contract? If a party breaks if a party breaks a condition of contract, the other party can take the case to court. That's litigation. The judge listens to the evidence of the breach and makes a decision on how the issue should be resolved. For example, let's assume that Jill signed the contract with McHugh Motors and paid 26,000 euros for a blue car, blue on the i10 car. On collection, Jill discovered that different Hyundai model has been delivered, and McHugh refused to refund Jill her payment or reorder the correct model. Jill decided to take McHugh Motors to court for breach of contract. The remedies of breach of contracts are, so it might be compensated, it might be resigned, or specific performance. So we're going to start with compensation. Compensation. The judge can order the party that caused the breach to pay compensation for any losses suffered by the innocent party due to the breach. That means the judge might order McHugh to pay 26,000 compensation to Jill for refusing to reorder the correct model of the car. There might be a contract to be resigned in the contract. And for the contract to be resigned, the judge can cancel the contract. This returns both parties to the position they were in before the breach of contract. If the contract is being resigned, it means both parties do not have any legal binding amongst them. So they become neutral to the contract. So the judge cancels the contract between Jill and McHugh Motors and others. McHugh Motors returned the discount paid by Jill to return the incorrect Hyundai model to McHugh Motors. The third one, specific performance. When we talk about specific performance, a judge can order the party that breached the contract to complete their side of the deal. So here, it means the judge orders McHugh Motors to complete their side of the contract by reordering and delivering the blue Hyundai i10 for Jill. That means the judge ordered that whatever has been agreed upon must be done. So these are ways in which remedies can be done if there's a breach of contract. So in the next class, we're going to talk about consumer conflict. Thank you.